Now we can start.
Welcome members. Today we have with us CA Dilip Agrawal ji. He will take on the RERA. First, I request all members to please raise for Institute motto.
येष सुप्तेषु जागृति येष सुप्तेषु जागृति कामं 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 कामंशो पुरुषो निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शितः सर्वे तदूनात्यपि कश्चन एतद्द्वैता
Thank you, Viral. CA Dilip Agrawal ji will take us through new Form 3 and Form 5 of RERA and precautions to be taken while signing these forms. Without taking much of your time, I will request our committee member CA Viral Shah to formally introduce CA Dilip Agrawal ji.
Thank you, Yashish bhai. We have amongst us a very vibrant and experienced speaker today, CA Dilip Agrawal, and I have the pleasant task at hand to briefly introduce him today. On the academics and professional front, CA Dilip Agrawal is a rank holder in BCom Honors. He is a FCA, ACS, Cost Accountant and DISA qualified. He has been practicing as CA since more than 33 years as the partner in charge of Mumbai branch in Todi Tulsian and Company and closely associated with BN Kedia and Company. His forte is RERA litigation and advisory as well as redevelopment management services. He has delivered and presented on matters connected with RERA, redevelopment, self-redevelopment at various platforms, which includes national conclave held by WIRC of ICI at various CA study circles, builders and architects associations, social organizations, various housing societies, etc. He was part of the core study group which wrote book on the compendium on self-redevelopment, consisting of around 50 renowned professionals from housing sector, headed by chairperson and IAS Subhash Lalla and coordinated by CA Ramesh Prabhu. His name is appearing in that book, which was launched by Honorable Chief Minister Shri Uddhav Thackeray at Nehru Center, Burli. He has contributed in RERA manual published by WIRC and he has received an appreciation award for that. He has served as deputy convener and convener of Borivali Kandivali East CPE Study Circle for 4 years and developed several leaders and speakers. He is currently serving as the deputy convener of RERA study group at WIRC. He is also active in various other extracurricular activities. He has been serving as the member in managing subcommittee indoor games in the Goregaon Sports Club and has served as the chairman of organizing committee of badminton annual tournament in the last week, which was much appreciated for its extraordinary management. He is serving as an introduction leader since 10 years in the landmark Worldwide Breakthrough Technology USA. He served as the captain of the IL body for 4 years. He used to lead and assist in the Landmark Forum and other programs and loves to make a difference to people's life. He is an early riser at 5 and is very passionate to play badminton every day early morning in the Goregaon Sports Club. And he's also won gold medals in different badminton tournaments in the club. With this brief introduction, we thank you, sir, for accepting our invitation to share your views on today's subject matter. Also, on behalf of Borivali CPE, we donate rupees 500 to the Speakers Fund, to the CABF Fund. Over to you, sir. And before that, we would like to present you a e-memento. With that brief introduction, over to you, sir.
Thank you, Viral Bhai, for your nice words and touching upon which are my passionate area in my life. And I really appreciate and acknowledge the person who has initiated to have this program with you and all the study circle members, Mr. Jawasa Wasa. And I also acknowledge the acceptance of the convener, Vishal Joshi. Uh, Without you core team working day night, I can see the pain and the efforts which convener, deputy convener, and the core team is taking to organize any program of the study circle for the benefit of members. It's only visible which is on the screen, but behind the screen, 1,000 kind of works has to be managed. I can see since morning how many calls I could receive. I could see how this presentation will be properly displayed, how members can be getting the uninterrupted deliberations or presentation by the speaker, and I don't get any hassle in my presentation. All those pains without having any other thing in mind, only to give the quality service to the members. I really appreciate all the core team members here present. And now, before I start the session, obviously it's my honor you have given me the opportunity. And some of the thing which I see, we see a fraternity deserve to get. And that I will touch upon, then I will switch over to the RERA subject. Say right now I can see lots of different acts and provisions are applicable to our clients, and I think we are more worried as a chartered accountant, and we are more into their intricacies and difficulties of the clients, as well as various provisions which are creating problems for us to understand, and all those pains we are taking for us. But we forget one thing. Say if we being chartered accountant going in every area of our practice, that may not give us peace, that will not give us mastery. And I'm one of them example, because as you heard, I'm practicing last for around 33 years, and I had been serving in different acts. I can say being company secretary, I had worked for limited companies as a company secretarial, some of the work, and then as a chartered accountant in the income tax, tax audit, limited audit, and all many other things, bank audits. But at the end, I was not satisfied to myself, because I was practicing and not getting the quality whatever I wanted to communicate and serve to the society as such. The moment I got opportunity in the RERA, I switched off, and I really, I mean it, I completely shut off. Still, I know some of the things, but I always say I don't know anything. This is my RERA subject, and other subject you can approach to the appropriate person. This is the yes or no made a huge shift in my life, and now I can proudly say I am a speaker. Before RERA, I was sitting one of the last bench. I was not person known to anyone, and even I was not recognizing my power. Why I am saying so, because we chartered accountants are powerful people in the whole society, the whole nation. We around 3 lakh chartered accountants are serving to the country to generate whatever our parliament has enacted. Without our support, those collections and implementation of laws are not possible at all. and therefore we are very powerful. I can see those who have passed the exams, but see, if those who have not passed the exam, you can ask them what is the CA course. They will tell whatever CA course is, who the chartered accountant is. After passing, we may have our own constraints in whole life. We being human being, we always have some constraint in life, and even at family and other places we will face that. But seeing your own power and connecting to the power, be at source, you can do anything you want, but be happy, satisfied, and love it, then you do it. Otherwise, just for the sake of getting something, my request is, please discover some of your passion, because there are lots of provisions which are making us opportunity, and if you choose those opportunity and serve them, then you will be first of all happy, and you will be enjoying it doing that, and then getting more whatever you can expect. Because when you are coming from the advisory side, having the expertise on the subject, people get it, people come to you and they will pay whatever you say. In general practice is the reverse. You are working hard, giving more time, at the when fees work is coming, they are paying whatever they think. ये तो बहुत ही ज्यादा है और ये बहुत कम है, इतना नहीं होना चाहिए उतना. There is competition over there, but here there is no competition or least competition, I can say. And with these words, for my CA fraternity, please act according to your choice, wisdom and passion, and believe me, any act of on this in our country is valuable, worth, and that may give you whatever you want in your life. Now let me jump to the RERA topic, which today's although topic is regarding all the practical aspects, one of the very important aspect is about the certification of chartered accountants, form 3 under RERA, and the form 5 annual audit report under RERA. Prior to that, there are other scopes for chartered accountants, like complying various other provisions, registering the project, registering the agents, and then providing various services as a consultant to the home buyers, allottees who are searching new flats. They don't have much idea, they only know some of the brokers. But nowadays in the electronic era, we have all the access with us. Once you know how to search it, then you can find out ABCD up to Z about the project, because everything is transparent. RERA made it very easy, and one can impact the decision of the buyer having knowledge of the project and the promoter. Now let me share some of the beginning synopsis what the RERA is before that, so that you can be reconnected. Some of you might be much aware about the RERA subject, but many of you may be distant places just listening ki RERA kuch hai and RERA karna chahiye. Form 3 and 5, there are certain parameters. Based on that, our professional brothers are doing their certifications and annual audit report. That may not be enough, but if you spend some time, at least 2 days time, I promise that you will get some of the complete overview of RERA, as well as some of the technical parts which may be of use for you when you are doing your professional assignments. Let me start with yes. Yeah, we can see the RERA was enacted in 2016, and thereafter from 1st May 2017 it was fully implemented. In 2016 it was partly implemented, and thereafter it has been very a renowned subject for the real estate builders. If you see why there are a certain need to make to give protections to the allottees, home buyers. There was a least accountability from the part of the promoters. Some of the renowned promoters were providing transparency and all those whatever they were communicating, but majorly they were suffering because there was no transparency. Sometime area whatever they were saying and giving built up area, super built up area, and so many things. There was various gaps which buyer were not aware to how to handle that. And since everyone was buying, that is why uh, everyone was following others. Now to bring the transparency in all those things, what project is, what the approvals are in place, what they are going to build up, what are the approvals they have taken, and what the buyer is going to take after building will be completed, all those things are now on the RERA side. Introducing professionalism, because in real estate projects, if you see, projects are self-monitored by professionals. It is not only promoter, it is monitored by architect, engineer, and chartered accountant. And then finally, annual audit report by the another chartered accountant. These people are monitoring virtually the proposal, a project by way of their own reports, which is uploaded online. And those reports are very important and critical. And we professionals are very much accountable for whatever we are submitting. We cannot say at the day end we have trusted the builder. No, we have been put different kind of obligation on us, not as a only professional. We are accountable for the information we are submitting for all the allottees. They are trusting on the information published. Now, various things, if you look at uh, mechanism, and they are seeing whatever things are displayed, whether they are followed, there are compliances to maintain those things. We can serve the promoters. This is, I can say now, after the act came into picture, around 35,000 projects have been registered in the Maharashtra. This is the largest in the whole country. One good thing happened is most of the promoters are registered, and if you see, out of they being registered, their drawbacks has come up. Now if you look at, there are around 4,588 unmoved projects, stalled projects. And whatever government or regulator can do, they can think on this now. Earlier there was no clue how many projects are stalled or not moving, whether they are constructed or on the halfway they are got stuck somewhere. Under the act, various responsibilities and obligations have been put on the promoters, and there are different dispute resolution mechanism, like filing complaints. There are certain sections which can be filed before the adjudicating officer if complaints are pertaining to some compensation. And there are provisions which are other than specified for 12, 14, 18 and 19 sections that are governed by the adjudicating officer under 71 and 72. Other provisions are applicable, are governed by members or the chairperson of the MahaRERA. And in the process to make it more easy, MahaRERA has come out with the conciliation mechanism. That conciliation mechanism is MahaRERA has set up from the builders association side as well as from the Grahak Panchayat side, means customer side, one member kind of bench where they listen the exclusively promoter and the complainant, and they try to convince them without fighting. If you can resolve, it will be better for both of you. And that is how many cases have been resolved amicably in this conciliation forum. Although initially most of the cases are being filed with MahaRERA, And before the hearing starts, in the first hearing, choice is given by the member to the complainant and the respondent that if you want to go for conciliation, why don't you choose to go first to reconcile and resolve amicably? And if you don't, then come back here. Your case will continuously be heard here. And cases are right now held up. Around 6 months to 1 year time is taken by them. In the COVID period, it has worsened, and then coupled with some of the members have retired, and later on, after some time, other members were recruited. Now, one more member is here with us, but prior to COVID period, we had two members. As of now, only one chairperson and one member. Therefore, cases are heard only with these two speed. Earlier, we had three multiplied, but now they are having the mechanism to resolve cases quickly, and cases are also multiplied. As of now, so far I understand cases are pending, maybe 5-6,000 are pending, and that is why instead of 60 days time, they are taking around 1 year time to resolve the complaints. RERA Act is very simple, and it consists of 10 chapters and 92 sections, and this gives you a edge so that you can come into this practice. RERA Act is a new act, and we all are aware about most of the real estate common provisions, and with those common understanding, if you study the RERA Act and you connect really with the subject, then in shorter time, possibly you can start your practice in the RERA. These are the 10 subject chapters wherein most of the time, if you look at our CA fraternity is concerned with chapter 2, where the registration of the real estate project and the agent. Agent cases are very less because it's very simple and the real estate agents register themselves. But as far as registration of the real estate project is concerned, it's a subject matter. It's a really matters for promoter how to register, what are the information needed, in which format, and all those things give us opportunity to interpret and guide them and advise them. And it's not only registration, it's a part of your advisory services also. And then if you see the chapter 3, which is the part and duty, functions and duties of the promoters, are all covered. It is a single chapter provision which monitors and regulates the promoters. And then rights and duties of the allottees. Under this, maximum number of complaints are being filed because they have certain rights and duties pertaining to making payment on time to the promoter. Whatever amount is due on installment, they have to make payment of those amount as per the payment schedule. Otherwise, they have to make payment of the interest as per the RERA provisions. Now, rest of the chapters in day-to-day life are not concerned with for our practice. Chapter 5, 6 is related to regulatory authority or central advisory council, and then 7 is for the tribunal. Again, this part is, I can say, a little advanced stage for the practitioners. Those who are practicing in the appellate tribunal, they are concerned with chapter 7, and then obviously the earlier knowledge and advanced knowledge of various case laws and various interpretation, time to time circulars and notifications are important before one goes to the tribunal practice. Now, offences and all those things are covered in 59 to 72 sections, and rest of the things are not that much important. And that is why I am telling you chapter 1, 2, 3, 4, these are the 4 chapters which will make you practitioner in the RERA topic. These are very commonly known things: promoters and registration, agent registration, filing complaint, discipline, financial discipline, and citizen-centric and transparency. Now, let us see what are the real opportunities available. Although some of them I have already explained you, but again, registration of the project and the agent, Form 3, and Form 5, which is due by 30th of September of every month after end of the financial year. Then quarterly updating the RERA sites of the project, because promoters are busy in their own work, and those who are qualified and knowledgeable people can take care of various things which have been implemented nowadays in the RERA are to be uploaded quarterly. And then seeing things about the allotment letter, agreement for sale, uh, so many changes has happened. I surprised that in the simple thing, it has become more complex nowadays, but yet somewhere it will get settled, because in the last 5 years there are experience with Maharera. With those experience, they are coming out with some kind of resolution, I can say, and they have come out with some drafted allotment letters, drafted agreement for sale, but some of the clauses might be harsh or very unworkable for the promoters. Their association might have approached Maharera, and after considering so many things, time to time they have come out with some changes in those things. Then appearing before the Maharera authority or the adjudicating officer, and sometimes defending the opposition party as a representative. We are as a chartered accountant are authorized under section 56 to practice under RERA. We can appear before the authority or adjudicating officer or tribunal under section 56. All the lawyers, chartered accountant, cost accountant, and company secretaries are allowed to practice. We can provide as a advisory role. We can provide services to the flat buyers by finding out by due diligence on the RERA site, and then suggesting them what decision they can make. And these are the broader picture which I wanted to just touch upon, so that you can get more connected when I will come about various circulars and some judgments and Form 3 and 5. Some of the protections available to the allottees under the RERA is, after implementation, transparency is there. Any allottee can see what are the approved plans and documents available with the builder. They can demand from the promoter, I want to see all the documents available with you regarding the project, and they are bound to show that. In reality, what's happening, we don't know. Most of us, we are aware that they don't give all those things, but Maharera site is the site where public domain, all documents are available for us to see, where we being professional are understanding things, and we can guide to the allottees. Aggrieved allottees can choose to file complaints. There are various rights given to the allottees. They have right to see all the valid documents. They have rights given under various sections, and if they are not getting registered, whatever amount they are making payment to the promoter, up to 10% builder can take, and thereafter if they collect without registering the project under section 13, promoter is taken hold to account by the Maharera, because normally as of now they are not penalizing, although there are provisions. If they are not following the provisions, they can be penalized. Penalty is very heavy, but since the RERA Act is new and authority is little lenient about compliances part, they give direction just to register the agreement for sale for the allottee. This is under section 13. And transparency in the area purchased by the allottee. Earlier, you all know that various terminology were used: built up area, super built up area calculated by God knows how. There were architectural some kind of built up area calculation, then some additions about some other staircases or some other common amenities area, and then buyers were just buying whatever area were disclosed by the promoters. Now RERA carpet area, there is no other terminology. This area has to be disclosed in the agreement for sale. Now allottee have now choice to see stage of construction, progress, and other approvals time to time, because RERA make it compulsory for the promoters to upload on the RERA site. And therefore, these are the things which is easily available and accessible by the allottees. There are various rights about the has been specified to protect the interest of the allottees. Now, there are various provisions which makes various things to do or comply by the promoters. So, I don't want to go in such lengthy process. I just wanted to give you some important clue. If you see the project is registered, there is much confrontation for us also as a being professional and some innocent professional or allottees. The promoter has given us a particular date for possession in the agreement for sale, and the RERA declared date of possession is something different. The which date will be valid for the allottee? Let me give you some of the example, then it will be better explained. Suppose the agreement was happened in 2015, and wherein the possession date was declared by promoter, suppose 16 December 16. RERA project registered in May or later on, and wherein promoter declared considered date of 22 December. And now whether 22 December will be applicable, because RERA is transparent act, everything is disclosed. RERA will be applicable when it has come into picture. Prior to RERA, that was not applicable. Then what will happen? Say, first of all, there are some interpretational issues. Later on, it has went up to even Supreme Court. Initially up to tribunal, then Bombay High Court, and then tribunal. All judgments have come, and they have unanimously in most of the cases you will find, other than based on case to case different regions, date declared in the agreement for sale is the patthar ki lakir bolte hain na, wo hai, that cannot be moved, that is the fixed, and the allottee is entitled to get interest from the date which is declared in the agreement for sale. Whatever date is declared in the Maharera is just to comply with, so that they cannot default in complying with whatever they are declaring now in the Maharera website. Henceforth, that will be applicable on them for the purpose of compliance of Maharera. Now, if you see the D and E, if some of the projects deadline has expired, their project registered period is now expired, they want extension. RERA had only 1 year extension time given, and thereafter RERA was silent. Now that matter went up to High Court. That will be taken care at the time of case close. But initially I can say on case to case basis, in the Neel Kamal judgment, Bombay High Court given the verdict that Maharera authority should act based on the case to case basis. It is not a blanket permission to every promoter that whenever they have expired, they can come and take the permission. They have to give the reasons why they have delayed, and they have to show why, how, and when they will be completing. If the RERA authority is satisfied, they can give the extension. It is not for 1 year, it can be for any number of years. There is no limit on it, and it can be below 1 year also. And in that case, promoter has to come with 51% consent of allottees. And there is a change in the specifications, and some whatever area has been designed or some layout has been approved, and based on that they have displayed, or some sample model flats have been shown, and subsequently as usual they want to change it. Prior RERA it was very easy, it was their choice, because every terms and conditions used to be mentioned in the agreement for sale, that promoter has every right, whatever they want till OC has come, they can do any changes anytime without any consent of the allottees. But all those terms are not binding on the allottee now. After RERA come into picture, RERA says all those adversarial conditions mentioned in the agreement will not be applicable. The fair condition will be two-thirds allottees should give consent in the specified format if a promoter want to change the layout or the plan or any specifications. Conveyance issue is already there in Maharashtra. Earlier also we were facing builders were not doing the conveyance, but RERA has the specific provision. A builder has to do that 3 years, 3 months from the OC date or whatever date is mentioned in the other acts. In our society act, it is 4 months time. Therefore, in Maharashtra, conveyance deed should be executed within 4 months of the OC in favor of the society. But as of now, MARERA is not focusing on this. This provision, I can say, is kind of slippery provision, not effective. But RERA is aware, they are pushing it to happen. They have come out with some changes in the various circulars, which make it compulsory that the promoter should upload the draft conveyance deed now. Now, any agreement which is any project which are going to be registered, this provision earlier no one was uploading. They were putting we will upload shortly or at the time of completing the project. But now these are the conditions wherein they are insisting to upload the draft conveyance deed. Now there are consequences on the promoters if they put anything false or they hide or substantial information they misinterpret in different formats. Even I can say these things are not mentioned. There are cases where hundreds of cases I could see wherein the various advertisements have been made either by the promoter or by somebody else or by the agents, wherein they have been soliciting something which they are not going to deliver, or some information about the RERA site, about the project were not displayed prominently, which the RERA Act wants them to display. And based on those, some complaints happened and sometimes suo motu actions taken by MARERA, and they have put a penalty on the promoters. Now, a promoter, I am not going to define, and I am not also going to define the Allottee. I will find that place in some of the judgment I have covered. These are very key key definition. What is the project? Who is the promoter? Who is the Allottee? We will see in due course when some of the judgments will come. Say registration fees, earlier it was much more. Now it is limited up to 50,000 minimum amount, and maximum 10 lakhs is same. 10 rupees per square meter or 50,000, whichever is less. This is the provision, deposits and withdrawals, very key provision for us to look at, and the promoters are also very much concerned about deposit and withdrawal provisions of the RERA. Whole focus is on this, and that is the main crux of the whole act, I can say, through which projects are monitored. Builder has to keep 70% of the collected amount from the allottees in the RERA designate account, and that has to be checked by the independent chartered accountants before it is used or withdrawn by the promoter. Banks are also given the guidelines not to allow them to withdraw until they submit Form 1, 2 and 3. Form 1 is the architect certificate, Form 2 engineer certificate, and the third form is by the chartered accountants. If you look at the Form 3, these are that form is I can say after 1 and 2 is complete, then Form 3 can be filled up, because those information are needed to come to the conclusion how much amount can be withdrawn from the project. And we will walk through those provisions. As a chartered accountant, you will require to see what are the specific things you need to check and what are the precautions when you are signing the Form 3 you should take care. Say ongoing projects which were are those projects which are going ongoing is not that I mean, but I mean ongoing project has been defined in the RERA is those projects which were already under construction before the RERA came into picture. And only those projects, if their recoverable amount is less than whatever amount is to be spent on the project, in those cases 100% deposit has to be kept in the RERA designate account. Now this part will be taken care in the form 3. What is the land cost, what is the construction cost, what things will be included and what not. Formation of legal entity, that is also say is a good move, I can say. Under the provision of RERA section 11 subsection 4 clause E, which make it mandatory for the promoter as a obligation during the process of construction itself, if they have crossed the booking of the units 51%, project is yet incomplete, it is under process. If their booking has crossed 51% of the total number of units, then they have to start with formation process of particular association of allottees or cooperative society or whatever name they want to create. Section 13 already somehow I have already covered. Now I can see the rights and duties of the allottees, that these are very critical, but yet it is somehow it is covered, I can say. This initial brief, I can say I have introduced you what the RERA is, what it is connected for us as a professional, and what precautions for the allottees and promoters are required. Now I am taking you to another slide. At this place, I don't think there may be much questions, but if some of you have any queries, please write in your chat box. I will request the organizers, if you have any questions, you can ask at this point. Yes, now I want to take you to the form 3 and 5. RERA CA certifications. This key area of our RERA practice, I can say, anyone who is in RERA practice or some other practice, most of chartered accountants are doing this job. You can also do. Only thing you should be aware about what are the changes are taking place, what are the various circular time to time are impacting your certifications, because your certification is not simple paper, it is something which is impacting the whole project. The builder is entitled to withdraw money because of your certificate, and we are responsible to provide whatever RERA time to time come with different circulars. If you look at RERA CA certification was started with very simple format, and there was long clarificatory guidelines by RERA in 2017, sometime in July, and then major changes happened sometime in I think 2021, 29th December 2021, when all these forms have been totally changed. There is a major shift based on their experience of various complaints, various things they could understand ki should be covered in the RERA certificates. Now, new format is now in place. Just I want to go by clause, but for that I should need the another Excel sheet which I can show you. If you see in brief, there are 7 tables given in the form 3. In overall 7 tables. Earlier there was no table regarding the utilization of fund and means of finances, but in the new format these things are added. And then one more thing is added is your observations, if any. very critical part, where we can have all those things mentioned in the report, which can safeguard and give the fair view and explain the ground or basis on which we have certified the certificate. Table A, that is first of all the estimation of the cost of the land. At the time of registration of the project, land cost has to be mentioned based on the ready reckoner value. Only estimated cost of construction is to be certified by the engineer when the land cost is to be taken as per the ready reckoner value. But here I would like to share some of my experience. There are projects where value of the land is much more than what the ready reckoner value is. In those cases, I will suggest you to take the your value, what is reflected in the books of accounts. Otherwise, promoter will not be entitled to withdraw from the RERA account, because based on the amount which has been reflected here, estimated cost of the project, within that cost incurred can be. If there is change, then one has to change the estimated cost by going in different module of the RERA. Therefore, this land cost estimation should be done with all those consideration. Now, provision for cost incurred. Again, cost incurred word you can find at two different places. One in the CA certificate, another in the engineer certificate. This word is confusing lot of time. What do you mean by the cost incurred, right? What I mean by this cost incurred is, say when the engineer is giving the cost incurred figure for the quarterly certification, uh, I mean by that cost incurred is, suppose there are 10-story building and having considered 10 crores of cost of construction, plinth area maybe suppose 3 crores, and then every slab consider 50 lakhs. Then if the first floor has come, first slab has come, then engineer will give cost incurred based on their engineering data 3.5 crores. That is the cost incurred as per the engineer. But when we as a chartered accountants are giving based on the actual vouchers cost incurred in the books of accounts of the promoter, we have to see payment as well as the supporting documents, and then we should conclude how much amount has been incurred. And that cost incurred is what is actually as per the books of accounts. Now, this cost incurred and the engineer's cost incurred can be different. But if you find in the column, you will find there these two cost incurred, whichever is less, to be taken as the cost incurred for withdrawal purpose. Pass-through charges, indirect charges, say these are the charges which are collected to be deposited to the government, different like GST, some other charges. I have seen some of the judgment 2 days back, wherein they have mentioned that pass-through charges can be which are not to be incurred for the construction purposes. Means some infrastructure development charges, maybe some society maintenance or some kind of deposits, BMC charges, taxes, water cess and all those things are some of the charges which can be deposited in a separate account, can be utilized for the specific purposes. These are the charges which are not having bearing on the cost of the construction of the project. If there are any changes in due course, suppose whatever estimation has been done and one has to revise those estimated figures, there is a provision in the RERA through the correction module. One can change those figures, and that is possible. That is not a Herculean job. It's very simple. Separate table has been mentioned. B is the separate table. Table A is purely estimation, and B is completely actual figures. And here, whatever we discussed accordingly is reflected. A is the land cost and B is actual cost of construction, whatever cost incurred as per both the certificates, engineer and CA, whichever is minimum is taken, and then some of the additional expenses are also there, which are added, and then table B, part 1 and B both are added, and that becomes the total cost of the project.
Sir,
Now, if you
sir,
yes,
can you share your screen?
pardon,
The screen is not visible, sir.
my screen is not visible.
No, no. The second part when you started, no, that is not there.
Oh, just a minute. Yes, please tell me time to time. Otherwise, I don't know why. Let me see. Now, is it visible, sir?
Yeah, yeah, it's visible.
Okay. Okay. Now, table C, if you see, this is the statement wherein collection part is covered. Out of the project, there can be two types of units. One may be sold or booked, other might be unsold. Here again, I can tell you in the format, there is no mention about the reserve and other some of the redevelopment units handed over to the other old tenants. But I have seen in the circulars, those things are defined and now covered also when we are submitting through the promoter sold and unsold inventory details quarterly. This is compulsory. And again, if you see that circular wherein this format sold and unsold inventory is to be uploaded, you will find in the bottom there is a note which says sold and unsold inventory should match with the CA certificate. Therefore, I interpret personally chartered accountants or the promoters should comply quarterly by submitting the CA certificate. Without verifying both these certificates and the sold unsold statement of the promoter, how it can be matching? Although in the act this does not require. If you see the act, wherein there is a requirement to submit CA certificate, which is giving the limit to withdraw from the project. If that is so, then consider builder has spent, consider on the land 50 crores, and now he started booking, and now he has started collecting 5 crores, 10 crores simply. Up to 50 crores, he is entitled to withdraw the amount. If you go with the amount spent on the project. But based on that 50 crores, if you go, then that might be exhausted, considered up to 2 years. What will be the scenario about the submission of the 3 certificates? As per the act, that there is no clarity. But when we see form number 5 is to be filed every year before 30th of September by chartered accountant, who will see whether all the compliances has been done by the promoter. Means form 1, 2 and 3 has been taken from the professionals, and based on those forms, they have withdrawn money from the bank. And it is the responsibility of the annual auditor to verify. If these forms are not in place, then what he will verify? Question is this. Therefore, now if based on those, if you interpret, then my interpretation is at least once in a year, form number 1, 2, 3 has to be uploaded. This is one interpretation. Then again, if you go into the circular which says that sold and unsold inventory has to be uploaded every quarter, and that should match with the CA certificate 3, form number 3, then that indirectly certifications to be done by quarterly. In some of the cases, consider project is 5-year-old and they have exhausted whatever amount is spent on the land and other things. Now booking amount is also slowly coming, and adverse is the situation. Their cost incurred is suppose 100 crores, and revenue collected, consider booking has been fabulous, and number of collections increases the amount spent, say 125 crores. Then in this situation, promoter cannot withdraw more than 100 crores. if the certificate has been issued by us and promoter has withdrawn up to 100 crores, then if he has collected further 5 crores and he could spend now suppose 2 crores, and now he wants to withdraw 2 crores, then to withdraw this 2 crore he has to comply with all these 3 provisions, form 1, 2 and 3, and based on that he can withdraw the further 2 crores. That is the extraordinary situation, but it can happen in some of the cases. Now comparison between the balance cost and receivables. This purpose is specifically, I can say, table D. You have to show the balance cost of estimated cost to be incurred, the stage of completion and a cost incurred, and the balance cost to yet to be incurred. And then there are 2 main things. One is what is the outstanding amount recoverable from the sold units, booked units, and then how much amount to be collected from the unsold units. One very critical part, when we are valuing the unsold units, there is no other choice except to value them on the basis of RR value, ready reckoner value. That is the circular meaning says. You cannot take any value of your choice, and based on the ready reckoner value and the recoverable outstanding, putting together, this is the total amount recoverable, and if the estimated cost to be incurred is more than this amount and the project is ongoing project, in that situation one has to mention 100% amount to be deposited in RERA designate account. If the project is new, it means after 1st May 2017 the project was started, and that project is new project, and in that situation, irrespective of estimated cost more or less, it does not have any significance as far as 70% is concerned. One has to deposit only 70% in the RERA designate account. Now table E, if you see the RERA designate account, they have provided specific columns. Now one has to give those details, although it is very simple, but somehow if you cross check and see your whatever figures you have displayed, it is putting more onus on us as a chartered accountant. You have to write the opening balance, you have to see the bank statement of the promoter, and how much amount has been realized, deposited and withdrawn has to be shown separately. It means manipulation chances are very less. One has to be transparent. And then the closing balance. Although this is very simple, but yet it is. Now problem comes when promoters have not kept separate account. जैसे हमको पता नहीं था, हमारा पहले से चल रहा था, कभी किसी ने ऐसा कुछ बोला नहीं, और अभी क्या करें, आप तो सीईओ, आप ही संभालो. Then that question comes कि how you are going to handle. If they have the RERA designate account and they have another normal account and they are honestly telling कि पैसा हमारा इसमें जमा हो गया, अभी आप बताओ क्या करने का है. Then that time you have to have, might be the similar format, you have to copy paste, or you can create the another column where whatever amount comes in as per your verification and disclose in the table G, where whatever things you could see has happened is going deviation from the circular, that can be safeguarding our interest. Now table F, means of finance. This is a very big impact on the promoters. One has to, like they are predicting how many floors they are going to construct, how many flats, what size and what duration. Then RERA thought, why not to predict about means of finance, how they are going to construct. The RERA authority has some background say experience, like as I told you, 4,588 projects are installed projects as of now. If those projects could have been properly arranged through the means of finance, they could have backed with the funding, then perhaps that bad situation could not have come now. That could have been completed slowly or gradually, could have get completed, but those are completely stalled for last maybe 3 to 4 years. RERA came into picture, only those projects are registered, and thereafter they could not move from there. At least some data is with the authority, and now they can think on how to come out of this, how allottees can get relief by getting their home, dream home, because some of the allottees are alone. They may not have much fund to fight with promoter. They may not have right fund to buy another house. Even they might be struggling to pay the rentals. Then what will happen to such people? What else to other allottees? What for they have done? They have booked the flat based on the promises done by the promoters. Therefore, uh, background of bringing this table is they should be transparent in declaring how they are going to bring the fund for the project. Now, if you see there are six rows in this. One is the own fund. There is no significance. Own fund means something. No, one can have any own fund. There is no limitations as of now given. Might be in future they may come with X percentage of funds should come from the own source. Might be, but as of now there is no such condition. And then how much fund is to be borrowed, whether secured or unsecured. What will be the drawing line limit? Total borrowed fund unsecured, it is indirectly from the other sources, our own sources, friends, relatives, or associates, or might be banking institutions which are giving without having any security. And then whatever amount is to be received being used for the purpose of the project. These are the sources, main four sources they have predicted and put here. And accordingly, we can be part of advising the client, thinking on what they really are planning for, and then suggesting them to make some ratios of the expenditure they are going to incur. Here you see that there are three columns. Number one is the estimated at the time of registration. This means this amount in the fifth column, total fund for the project should match with the total estimated cost of the project. This is the first thing. Second thing is all those four columns, rows which are giving you the choice is to be considered appropriately with full thought on their plans, such that if these are deviation, when the last column, if you see actual age on particular certification date, if these are fluctuating, then how many times you want to change it? To avoid those things, one has to be cautious. And then middle column, if you see proposed estimation, and that is nothing but the repetition of the first estimated column until you need to revise the estimated figure of the project. Suppose basic fund initial estimated cost is coming in the first column, and then subsequently you have changed those estimated figures. Those estimated figures will be reflected in the second column. Overall, total cost of the project, but ratios of the proposed estimated figure, if you are changing, again that will be changing, because ultimately we as a chartered accountants are certifying only actual columns. Rest of the figures are to be certified by the management, which we are putting in the certificate. Now, if you see the comments and observations, this is something which most of the CA certificates were not having earlier. Some of the professionals, being cautious about impact of various other circulars provisions, they are safeguarding their interest, putting some of the notings. But here now specific column is given, so that if CA has any observation or comment about the project or any area of the certificate which they have certified, should mention here. Now, any exception in the land cost and the construction cost, which we already discussed, whether it is a deviation from the RR value or it's going for the uh, uh, actual value, or sometime based on the complexities, there is a JDA projects, there can be some understanding, revenue sharing, area sharing, there can be different kind of game calculation for project land, those things to be considered and should be explained here. Now, any discrepancy, if you have observed in the operation of the banking account, should be noted here. Sold unsold inventory, you have to see that these are matching with those things. Now, pass through charges, if you have some queries or things to be noted here, you can explain for the transparency purpose. Deposit and utilization is also very critical. As you have seen, the deposit and withdrawal amount that are to be disclosed there, that if you have some deviation, something that has to be mentioned over here. And in anything else, because we can find many times many deviations, there can be when you certifying form 3 or form 5, which is not mentioned here. I am going to tell you practical things. What one should check, first of all, you are going to see the sold and unsold in table C. If you go back to table C, this is sold and unsold inventory you are writing. How are you going to certify that these are the sold and these are unsold? There are 2-3 milestones which you have to keep in mind. Number one, you are seeing the bank transactions. Whatever amount has come, you have to see whether it is any deposit by the family members, associates, then it may be unsecured loans. If that amount has come from any investor, like putting money in the project, and builder is not showing those things to you or by them, they have just collected and not given out of the box some of the document. Yes, मेरा security रख लो आप, ये later है आपके पास. Then that may be the problem for us as a chartered accountant. You have to be cautious. You should check it. You should verify what who has given and what is the documentary evidence. In the process, you will get it. You will find it, the reality. And if not, then at least you have the precautionary note you can put in G, that these you have observed, you could not find, but they have shown like unsecured loan or something, but you don't have any proof. Whatever they said, you trusted. Now, there can be the booking form, or there can be allotment form, there can be money receipts. These are the basic fundamental documents which are available for your verification. While you are certifying amount received, under which, from which flat you got the amount, which flats are cancelled, which flats are resold, what are the documents available, you should reconcile that, so that you are safeguarding yourself and justifying as a professional person, and allottees are having those figures which really worth for them, that are the real picture. Prior to RERA, these things were not explained to anyone. Now these are the responsibility through the chartered accountants to be verified, and therefore it is very key documents which we need to verify. Booking form, allotment letters, money receipts, sometime any kind of cancellation or some other correspondence, what are the process they have maintained for keeping individual flat wise records. And if you go through, then you will find some clue, and then based on your best judgment you can put in the report. Yes, I think form 3 so far explanation part is over. I will request members, if you have any query at this point you can raise. I am stopping this PPT for the time being. If you have any query, please raise the queries.
So we have received some queries.
Yeah.
Shall I read it out?
Yes, sir, please.
Okay. The promoters have not actually maintained the designated bank accounts due to improper knowledge and also due to lack of knowledge on the part of the banking people. Multiple bank accounts are maintained by the promoters and 70% is not actually maintained. So what happens in such a case?
A very good and practical question. I appreciate Sandeep Ghelani ji. You have raised the question of many chartered accountants. It is not your question, it is mine also, because we are facing these kind of problems. But see, what happened is happened. Postmortem तो आप नहीं कर सकते हो, but एक चीज तो आप कर सकते हो कि now henceforth you have to comply with, or the moment you will update the promoter कि these are the consequences if you are not complying with the requirements, then you can put mail also, so that they cannot say कि I was not aware. And if responsibility come on the chartered accountants, at that time those mails or some communication will be helping you, and put those things in the observation notes. First thing, from our perspective, our object is not to say put the promoters in some trouble. Our objective is to help them to come out of this kind of non-compliance, and they should, if they are doing that, that also you can put in the note. From particular date they have streamlined, and earlier they were having this kind of notion that not maintained as per the requirements, but they have withdrawn money which is required as per the CA certificate. They have maintained that, at least will be safeguarding them. And if you are not satisfied even with that, whether they have withdrawn money as per the CA certificate, then you have to qualify. There is no other way. You cannot safeguard them and putting your at risk. Yes, next question, sir.
Is there any due date for filing the quarterly form 3?
Sir, I explained you, there is nowhere mentioned any due date. If I repeat, then other things will be missed out. I can, in short, I can tell, better you file quarterly.
Okay. Next question. Can a builder give conveyance of cooperative registered society to any other builder, ignoring the society request? What are the consequences if they do so?
Builder cannot give, just in the redevelopment, when the builder enters into the development agreement with society, additional area is sold to the existing members. How to reflect? Acha, कौन सा point है आपका sir?
It's one question about, can a builder give conveyance
of cooperative registered society to any other developer, builder, ignoring society's request? No, he cannot do. He cannot do at any cost. Even if he is doing that, will not be valid in law, because RERA is the act which is superseding, and during the tenure of the RERA, I am not talking about prior RERA period, those matters will go to the civil courts, and court will take a call what will happen based on the fact, case to case. But after RERA come into picture, RERA is superseding provisions. If RERA provisions are specific and other similar provisions are also there in the other acts like MOFA or something, then RERA Act will prevail. If RERA is silent on particular provision and other act is having some provision, then other act provisions will be applicable. It's a harmonious act. It's not this kind of act. Now, if the builder is developing particular act, RERA says land has to be conveyed to the society. All the common amenities has to be conveyed to the society, and that comes under the section 17. This builder cannot transfer the land right to some other builder or anyone else. Yeah, next.
in a redevelopment project, when the developer enters into a development agreement with the society, additional area is sold to the existing members. How to reflect such additional area in form number 3, and also let us know how can such additional area be sold to the existing member under the RERA.
Sir, first of all, very good question. I can say it is my question. I had put that question when I was writing a topic on this RERA versus redevelopment projects in WRC manual book. And that time this question I had raised amongst those all luminaries were knowledgeable people. There was no specific answer to this. Yet, we were of the view, anything which society members are getting either free of cost or equivalent to the old area, that is coming under the landowner promoter category, they are not protected by the RERA. But if they are buying something as a Allottee, and that area and that additional flat, if they are buying, is protected under RERA, and whatever relief as a Allottee be granted to them also.
How to disclose the bank details in Form 3 if multiple bank accounts are maintained in which the project funds are deposited and are withdrawn, and whether the details of deposit and withdrawal only from or for the project should be disclosed.
Already I explained this part at the time of, yet I am saying something like they have given the specific format. We have the right to disclose in by way of some additional table or some extra pages or some explanatory note. We can mention all the name of the bank's account numbers, and if something is deviation, then highlighting all those bullet points, because those deviations are very critical for the RERA project being successful. And if we are not highlighting all those things, then those things will come on us ultimately. If RERA is taking any action, then RERA will take such actions on us also, because I have seen one order in Gujarat wherein the CA has given the certificate. They did not verify the total trial balance, their balance sheet, and builder had collected money, and they did not reflect that particular amount was collected from particular Allottee and not shown in the booking amount. And then finally, that person, when he claimed and RERA verified, then I think that CA has been blacklisted.
If it is not possible for the promoters to furnish the estimated means of finance as on the date of certificate, then what to do? And further, how to furnish the amount of the means of finance estimated at the time of registration of the project, which is more than 5 years.
Sir, if it is not possible for the promoter to furnish the estimated means of finance, CA cannot certify, and builder is at fault. We are accountable when we are provided with certain information, right? And whatever is needed, maybe CA is certifying information, engineer has given the certificate, cost incurred, right? In the table B, actual cost incurred by CA engineer certificate, and then we certify whatever is incurred as per the books of accounts, and then whichever is less we are considering for the withdrawal purpose. How, what if the engineer is not giving that certificate? We cannot certify. How can we say we are qualifying कि engineer ने नहीं दिया और हमने अपने basis पर इसको withdrawable limit set कर दिया? You can set zero value. Maybe they have not done anything, only paper में आपको खर्चा कर दिया हो, ये भी तो हो सकता है.
Next question, where to show the sales and marketing expenses?
No, it is not allowed, because under the CA certifications, marketing and distribution or advertisement expenses are not covered.
Should the cost of the total in table A match with the actual figure in table F?
Say table B is the actual cost incurred, right? And when we are talking about, yes, that should be matching. Yeah, actual cost of the F table, that should match with table B, and table A should match with again table F estimated cost.
And the last question, sir, if the builder has not provided the elevation of building as per the design, then can the society members file complaint against such builder under RERA by mentioning that as the builder mentioned in their agreement, and that they can modify as per their will?
First of all, yes, first part of the question, Allottee has right to file complaint, and they have right to get the compensation based on, there may be some reason and there can be some basis, and therefore this kind of compensation is awarded by AO, adjudicating officer. This cannot be judged by the IS officer or some other member as per the Supreme Court new take judgment. Now, question is whether when builder second part, builder mentioned in the agreement, they can modify as per their will. No, as per their will, they cannot do. They can do with the permission of 2/3 members. There is a specific circular. I can come in the circular section. Then one can see there is a specific column and those approvals, signature of the allottees, and then 2/3 is granted. Then that can be done.
Okay, sir, you can continue with your presentation.
Yeah, thank you. Any member in the process, if you find that some question is making you disturb and you cannot move forward from there, you are stuck, you are most welcome. You can raise your virtual hand. We can take up that question. Okay, now let me take the form number 5 and then quickly we can move to other part. Yes, now I am sharing this. Is it visible, sir?
Yes, sir, it's visible.
Okay.
Okay.
Now, annual RERA report, we are going to see this. First of all, as per the provision, if you see, this annual audit report can be done by the statutory auditor, if you see the language of the act. But in various platforms, we discussed about this aspect, whether the word statutory means the only person who is signing the annual audit report can sign this certificate or somebody else can sign. Say, first of all, there can be 2 CA in one project. First of all, consider the regular auditor is signing form 3, then how he can sign the annual report under RERA? He cannot. It means there is a option or there is a condition wherein other CA can come in and sign the form 5. Second situation is RERA is a statutory act. Under the act, whomsoever is signing the report is called the statutory auditor. And there are projects which can be, say, proprietary concern or some partnership or LLP or private limited, whatever may be the say organization, but based on various things under Companies Act, there are some statutory audits are happening, and but other than the Companies audit, there are tax audits. If there are certain turnover, then there are statutory annual tax audits. But there are firms where is no such obligations for any statutory audits. Then various considerations, I conclude and I could make up my view that statutory auditor in this case can be other than the CA who is signing form 3. Okay. Now let us see fund deposit and utilization versus withdrawal. This part is now the subject is very simple in the form 5. If we look at these 2 parts are coming there, utilization and withdrawal and deposit, these 3 parts if you see, then 4 tables and 2 sub tables introduced, and shortfall deposit amount to be provided, date wise details of the excess, withdrawals to be provided. जो भी excess withdrawal, if they have withdrawn more than whatever Form 3 is saying, and then those date-wise withdrawal list is to be provided in the form. Date-wise details of non-utilization for the project cost is also to be provided. These are the new format asking. First of all, any form is to be countersigned by promoter. For earlier we were having the CA certificate or annual report signed by us as a chartered accountant, but now it is to be signed by the promoter also. Because in the RERA hearing at many times they have said, हमको तो नहीं पता हमारे CA ने क्या किया. To safeguard all those things, it is better that even promoter is also required to sign. It is safeguarding our own interest also, because they become the part of the information provided. Now, if you see the table A, deposit parts, total amount collected from the Allottee from this financial, there are two columns in that. First is during this fiscal year and the till now, till date of the certificate. Then accordingly, these figures will tell you what and how to reflect those figures in the table. Percentage of the amount to be deposited based on the ongoing and new projects, 70 or 100%. Amount to be deposited as per the certificate. If 50 amount is collected, then 70% will be 35. We are going as per 70%, presuming the project is new. Now, total amount deposited in the designate bank account, consider 30. Amount to be deposited was 35, but actual amount deposited was 30. Then in that total percentage of the amount to be deposited becomes 60%. Then how much is the shortfall? 5%. This is how one can reflect in the table. Now table B, withdrawal from the RERA designate account during this fiscal as well as up to the date. Opening balance, deposit, withdrawal and balance. This is what is there. Now again there may be some CA who may ask कि उसके बहुत सारे account हो तो क्या करेंगे? Same thing will apply. Either all figures for the fiscal should come in this, and you can put by way of note that they have, these are the accounts and we have calculated all the deposits or withdrawals of all those accounts and put in this table. And second point you can put, although as per the RERA provisions, all the deposits should have been done in the RERA designate and this has not been complied with, although the promoter has agreed to comply henceforth. और यदि पीछे का रिपोर्ट में आपका सेम नोटिंग था और अभी भी सेम है, then there is a problem for the promoter. If any action is taken by the RERA authority, then they can put any penalty on the promoter. CA to certify withdrawn amount utilized for the project cost or else specify date-wise details of the withdrawn amount. And this is the amount which is to be shown. Withdrawal amount utilized for the project is the basic intention of having this certificate is the fund utilized for the project. Whether the amount is withdrawn when the cost is incurred and then based on the certificate amount is withdrawn, then obviously amount withdrawn is always less than the amount utilized. And that is, if there is any deviation, then date-wise details has to be mentioned here. Table D, any comments, observations. Whatever we have discussed in Form 3, that is same thing. If the Form 1, 2, 3, whether they have submitted or not submitted, or any adverse comments are there in the forms, and those things you can reproduce here to point out summarily for the whole year. And anything which you see is to be reported as a statutory auditor, that you can put here. Now I think these two parts we are more concerned for has been covered. There are very important things which are yet to be covered, are various circulars. as well as few judgments, very landmark and important judgments, which I could see are impacting in my day-to-day practice area as a litigant, RERA litigants. In the RERA tribunal also, we are using those judgments and getting the favorable judgments in favor of the Allottees, or sometime in favor of the promoters, because we professional can appear in one case for one party. Yeah, any questions, sir, as of now?
Questions were only from some questions were left out in form number 3 only, sir. So,
No problem, sir.
Okay. The inventories which are unsold and are given to bank as securities against loan, whether to be disclosed in unsold inventory.
Yes, obviously. Say all the inventories are, when the project is registered, promoter has to disclose all number of units with the size, how much square meter and what 1 BHK, 2 BHK. They have to segregate all those कि क्या size है उसका. Even 1.1 is different than that is coming under the different type of apartment, because the units are called there as apartment, and all the units, suppose there are 100 units, 20 units are given as a security to any of the financer. Even those units are units, 100 units. Now, if the builder has not sold but given on the security, unsold units will be there, because the secured creditors and those parts, as of now, in my opinion, RERA has been lenient for this. They are not coming up strongly to protect the interest of the allottees from the financiers' point of view. Financiers' fund are protected by securing something, and allottees' security is to that extent compromised. Because if they have given 50 crores of loan, they will recover by way of SURFACE Act or NCLT or something else. At that time, Allottee is what? They are protected by saying that you are also considered as a financial creditor. But how much? Up to the extent of your flat, but flat is not constructed. Then what? To that extent, there is some injustice, but whatever is there is this.
Sir, in form number 2 of the engineer, it is mentioned estimated cost of construction incurred. How can estimated cost be incurred? Is something wrong in the form, sir?
No. Form 2 says two parts. First is when the project starts for registration, right? In the very beginning, at that time, estimation is to be given by the engineer for the construction cost. And then land cost is to be declared by the promoter in table A. And if anything has incurred about these two aspects, land and development, has to be verified by the CA in table subsequent table B. And then later on, if they have not sold, then that will be 0. All will be unsold inventory in table C. If they have sold something, then there is a problem to the promoter. Before the project is registered, how they could sell? Yes, if they can sell to somebody as a investor promoter, that is allowed. Then they will not be protected under the RERA. These are the few practical aspects, will come on case-to-case basis.
Next question: can we rely on the land revenue as mentioned in the form issued by any other CA in form 3 of the previous quarter?
Yes, one has to. Whatever land cost one CA has disclosed, and if the current CA know the provisions of RERA, and now whatever figures he has mentioned, obviously he must have mentioned based on the facts of the case. If it is incurred from the books of accounts, if it is estimated based on the declaration by the promoter, he can, for his sake, he can take those declaration copies from the builder.
The last one: how to take the benefit of RERA for redevelopment of society?
Say, first of all, how to take benefit is, I don't think is a appropriate question, because RERA is not to give you any benefit, but it is here to bring the transparency and protect the interest of the allottees if something wrong happens with the allottee. And RERA is not protecting any members of the society, because what RERA says, they society being the landowner of the particular land, they comes under the category of promoter. Promoter's interest as a flat owner is nowhere protected, because ultimately they are the members consisting in the society. Therefore, their interest to that extent is not protected.
Now you can continue with the presentation.
Thank you, sir. Now I am walking through the some of the important circulars, right? Uh, Overview of important circulars. I am not taking every circular, because there are least important, or they might have expired because of subsequent superseding circulars time to time have been issued by RERA. There are various circulars issued. I can say number. There are lots of circulars. Even in the recent few months time has come, and every day every new circular is more compliant and more impacting as far as project is concerned. Procedure for transferring the promoter's rights and liabilities to a third party. Say, under RERA section 15 subsection 3, there are provisions if any promoter wants to transfer his majority of rights or responsibility in the project to any third party and any third promoter. That earlier they used to do that, but nowadays they cannot do. For that, they have to comply with certain provisions and take the approvals from the allottees, and there are specific certain provisions if proprietary concern or LLP is converted to limited or private limited companies under the provisions of law. And under section 47 of the Income Tax Act, if 75% of the shareholding pattern or the ownership remained with the same person, then those things are not considered as the transfer of or assignment of the promoter's rights and responsibilities. But in other cases where anything is such thing is happening, they have to comply with. And this second circular, first circular was 19, and then in the year 2021, some modifications has come and some clarification has been given by way of circular 24A. Now, as regards the consent, I will touch upon more in detail about because this is the very practical aspect. Because if the project has been delayed or some changes in the specifications has taken place because of DCPR 2034, some benefits is accruing to the developer, and now he wants to add few floors or add few flats or do something which is impacting the specification or layout. In those cases, there are specific format wherein very small resolutions guidelines is there. One has to take the resolution passed by 2/3 of allottees or 51% in different various cases. If extension is required, 51%. If changes, then 67%, 2/3 majority. And what are those? Let me take this. Is it visible? Circular? I presume it is visible, right? if you see that circular clarifying the consent of allottees under section 14.2 where the specification changes, then 2/3 and 7.3, then when the extension of the project is required 51%, and format is very simple here. Serial number, first of all, how many units, total sold, unsold, consent taken, and percentage. Based on this one line, they see that number of percentage is okay, and then they give the approval. And if sign on each individual either can be mail or through the letter individually, and then in this format, signature column one can write consent enclosed. One has to attach those individual consent or mail or whatever mode one has adopted, and accordingly this list is the summary list, which is one important part here is in every page. Suppose in one page it is not enough to cover everything, then on every page one has to mention this detail, that for what purpose this consent is being taken from the allottees, and wherein the registration number and the resolution part is mandatory to be mentioned. Now, as we discussed in the earlier part, sold and unsold inventory, it's again very important. In the sold and unsold, only important point which I wanted to disclose is, see, there is one line which is mentioned that it should match with the CA certificate form number 3. And based on that, since the sold and unsold inventory is to be uploaded by the promoter every quarter, and that should match with the CA certificate, and based on this, we should presume that we have to give the CA certificate at least quarterly. And these are the two circulars which has been modified. First one was 2021 June month, and then April 2021 another. They have rectified with certain. Earlier they had sold and unsold inventory. In the sold, unsold, they have mentioned specifically even the reserve plots and allotted to the redevelopment society or kind of thing will be covered in the sold units. It will not be covered in the unsold units. Now standardized formats for declaration. When the RERA Act started, there was a very gray area. Everyone every promoter was registering the project when they were getting initially with IOD or CC or both. In those cases, projects got registered. Around 11,000 projects got registered with either with the IOD only or both. But later on, if you see 2021, they come with the circular that one has to upload immediately. They get further CC. It means what? The allottee, they are buying the flats with the RERA registered projects, but projects are not having the CC up to the given floors, whichever is registered in the RERA. Suppose project is registered up to 20 story, and builder has not paid the TDR or neither they have paid the premium to get the further CC up to top floors. Then what they do with the limited fund, they pay some amount with certain compliance, they get further CC. And consider in few cases, if they have got the CC of up to second floors, and RERA, in my view, till now, I didn't see anywhere where they have put any kind of cap on promoter that they cannot sell it. They have kept it open for the allottee to be wise enough to see whether they are buying the flat which are covered in the approved plan or approved CC or not. And therefore, this is very important part for us to know as a professional and guide if somebody come across and take your opinion. Second, amendment in the circular. Say this circular is mainly for suppose any complaint is filed with Maharera and they want it to give the opportunity to attend in the conciliation after filing the case. They can go for conciliation. That is the choice given to the both the parties. If they choose not to go in the conciliation, they can still remain in the regular hearing with Maharera. And if one go for the conciliation, that is after conciliation results, if they are not satisfied, they can come back to the same Maharera regular hearing, or if whatever happened is not complied by the promoter, then still they can come with Maharera that they have promised and they have consent terms and they did not follow that, and that is how RERA will support them without having the further filing fees for the complaint. Hearing of the complaints on seniority basis, cases which we file in Maharera, suppose everyone is expecting कि मेरा केस पहले आ जाए, कैसे आ सकता है, क्या कर सकते हैं, we can't do anything. In exceptional cases, on urgent hearing, if we file and that is justifiable, then we have to go and convince them and they can take it on priority. And they have given the cases where there are exceptions. If we, yes, if you look at there are exceptions, there are 4-5 exceptions where the complainant is suffering from serious life-threatening illness. Superior forum like tribunal or courts have directed the RERA authority to listen the case within the given time, or complainant in respect of the same project are clubbed together with other cases of the similar nature, and those some of the cases are new and some of them are old. Disputes has been settled between the parties. These are the cases are taken on priority and disposed of. Garage is very critical part. Agents registration I am not touching. Garage and parking issue is very important part. There is a circular. One should be aware about what the RERA circular says about parking. Before the RERA, there were lots of dispute as per the High Court or Supreme Court judgments. Nihal Chand, people were seeing something in the judgment and actually happening something different. But now at least someone is there to watch. I declare 5-minute break because my thought is blocked.
Yes, sir, you can take a 5 minutes.
Yeah, 5-minute break, please.
Yeah, no issue.
So what we can do?
Yes, sir.
We can have very key points, which is very important for our members. Now, in the recent one case circular, RERA is asking for promoters to submit all the three formats, 1, 2, 3, for withdrawing the amount to the bank, as well as they have to upload the letter requesting for withdrawing the amount up to whatever drawing limit has been set in the CA certificate. RERA has come with some circular which is saying what are the documents which will be available for the public domain. If you see earlier, there were certificates of CA were not publicly available. Now, a specific mention is there, and RERA site has been upgraded to that extent. And form number 1, 2, 2A, 4, and 5. These are now some of the forms which are mentioned here, form 1, form 2, 2A, 4, and 5. These are now available for public domain. A part of that, whatever sold and sold inventory, obviously that was for the allottees. And CERSI report, whether the promoter has taken loans or something against the security of anything in the project. And declaration about the commencement certificate. These are the things which are now publicly available for anyone. For online modification, there are say convenient documents before the hearing takes place. RERA says everything is heard online. Out of the complaints file with different documents, only key documents, those are called convenient documents, are to be physically submitted with the concerned department of particular member. There is CERSI report. Format is given. There is CERSI site where from one has to get the printout after putting the PAN number, name of the company or firm, and if anything is registered over there, that has to be uploaded and to be uploaded at the RERA site. This has become compulsory also for new registration. Execution of conveyance deed, that has also come in the circular that one has to execute the registered conveyance in favor of the association of allottees within the stipulated time of section 17. Procedure for validation of form 4. This is when the project is complete and certain compliances have been completed, project has got the OC, then promoter has to file form 4, and after that he is relieved from the compliances as a promoter for quarterly updations. 26. That CERSI report is rectified subsequently, and that is taken care. Now, registration of sale component of redevelopment projects. Say there can be redevelopment or SRA or something wherein there are commitments to the existing members, and there are something unsold or sale component. For sale component, one has to register with RERA, and those registered unsold flats or the people who are buying out of the sale components are protected under the RERA. Standard operating procedure, if someone wants to file complaint as a professional or as someone an independent complainant, one has to follow the process which is given in this guidelines. That's all. Say as regards the filing various circulars, I can see I have covered most of them. There are few things which is not here. I will mention you orally. Say 12th of August, last circular came from RERA, which is very important as far as impact is concerned. Because for new registration of any project, one has to file the modified form, model form model allotment letter, and uh, model agreement for sale with the deviation report. What they say, deviation report, which is not as per the model agreement or the model allotment letter, they should highlight those portion which is not what is there in the model, and they should also give on the separate letterhead specifying what is there in the model and what is not there, and what specific they are adding or doing something different. And that is until they do that thing, registration is not done, which was not earlier. It is a Herculean task, I can think. Even many people's projects has got stuck because of last new guidelines. Even the RERA staff are also not much aware about what to do. Possibly they might be taking assistance of the seniors, and therefore the guidelines which came maybe a few days back, maybe 2nd or 3rd of August, is again revised on 12th of August, because they are very cautious. We had one seminar. I am associated with one association, RERA Practitioners Welfare Association is registered, and I am one of the committee member. We had organized one seminar wherein RERA chairperson and the member and the MCHI CREDI president was there, and that program was organized with the association of these two, CREDI and this association. Then I could listen the chairperson, his vision about the projects which are stalled and those who are getting registered newly. What vision he has created about this are, they don't want to spread the cancer in the new projects. Means they want to be, they want to have system in place such that if the projects are getting stalled and non-compliant, they are not following up whatever circulars or guidelines are there, and RERA is somewhere got stuck to deal with such a Herculean job, such a big task, such number of cases. Now they have put separate team for working on the stalled projects and to resolve something with the consent of the state government. That may take some time, but will be coming up soon. And at the same time, new projects are dealt with very strongly. They must be law compliant. They must be very clear. Whatever RERA says, they are complying all those things. And therefore, every now and then, RERA is strict in checking all those specific documents, and they are coming up with various specific circulars and suggesting. They have put up their separate team to guide people, those who want to register projects and they are stuck because of some of the issues they are handling during the course of registration. Yeah, these are the part of the circulars. I think we are well within the time. If anyone has got any questions, yes, Vijayji, we can take up those things.
Yes, sir. What are the procedures if the existing developer transfers the project to another developer?
Yeah, I have already explained in the circular. There is a specific, there are two circulars regarding this. One is of 2019, another is of 2021, wherein all the process is given. One thing which is important to know is majority of holding of the existing promoter, if they want to transfer, then they have to follow that circular. If they want some investor or some person to be part of it, but that is not majority, they can do that. There is no further compliance, only disclosure and updation, and whatever things they are doing, they can go in the change module and they can do that, and then they can upload whatever new agreements and some collaboration things are happening with them. But if they really change hands, they are shifting, then in most probably there are two major things. One, the existing promoter is not relieved from his responsibility as a promoter. All the obligations will continue to be borne by them. A part of that, new promoter has to submit their different form B and the declaration about taking charge of all the responsibilities and obligations of the all registered agreement for sale, which has been promised by the old promoter. A part of this, there are uh, 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 consents needed, and hearing will also take place. One has to file on the secretary@maharera.mahaonline.gov.in. They have to submit the application for change of promoters under section 15 subsection 3. Yes.
In table B of form 3, we have to report the interest and some of the principal repayment. Do we have to report only the loan from bank or NBFC, or unsecured loan also to be reported? Or do we have to show only the interest component, as real cost is the interest?
Say in the form B of form 3, form table B, they now their circular, earlier circular of 2017 was also in the format there was no clarity. They have mentioned interest and principal, both they have mentioned earlier. Now it has been rectified. If you see the new form, only interest portion has to be covered. Repayment of loan is not the cost of the project. Interest is obviously is the cost of the project.
What is the penalty for any default under RERA by a builder or a CA or Allottee?
Say for the builder, if you want to see what penalty can be put on the builder, you one should see section 59 up to 70, 70 I think, or 69. That is the penal provisions under different sections, what kind of default. But in broader sense, one should understand penalty is up to. It is not some kind of 5 lakh, 10 lakh. No, it is up to project estimated project cost of the project, 5%, and in some cases 10% up to. And therefore, there is a huge impact on the promoters. They are afraid. They cannot dare to be non-compliant. If something will start from the RERA side, then you will see next day we professionals will be getting the lots of opportunity to support the promoters. As of now, whatever we are seeing is very, I can say, peanut. The moment compliances part is rigid and strict, we professionals have to be knowledgeable, and we will get abundance of the work in the RERA front.
Now, commercial units given on rent to be treated as a unit sold or not?
No, if suppose anyone is giving anything on rent, it is not sold. There is a, I will cover in one of the case, Lavasa case. If you see the definition of Allottee under section 2D, it's very clear. Allottee, buying or doing such things is covered under that. Taking on rent is not covered under as a Allottee, and therefore it is not covered.
No. For conveyance deed can be issued for part project or for complete projects only. For example, ABC being completed and OC received, but D wing work is going on. In such case, can Allottee can ask for conveyance deed?
No, first of all, no. If the OC has not received, conveyance deed condition is after completion of, after getting OC within particular 3 months or 4 months applicable time. When project is registered as one, if for the ABCD all the 4 units are in one project, or there are 4 different projects, it depends. And then further depends on the full layout. If the builder has disclosed that I have the one layout and I have these projects, and then based on whatever they have declared on the RERA site, they have to do that.
Okay. The last question: a developer does not obtain periodic form 1, 2, and 3, but nevertheless withdraws money from RERA designated account. Then, in such withdrawal to be reported as excess withdrawal in form 5.
Say if the form 5 is worked out by us as a professional, then we have to mention all the facts. These are limitations of whatever you are doing, and whatever, if form 3 is not there, then obviously whatever they have withdrawn is excess, because annual auditor is not going to see whether they are having the withdrawable limit and whatever is there, because they are not entitled to do the Form 3 audit. They are doing only 5. They have to depend on Form 1, 2, and 3. Based on that, and documents, bank statement, other things available with the promoter, they have to comment in the Form 5.
That's all the question.
Yeah. Okay, sir. Thank you. Now, let us move to the very interesting part, various judgments. Judgments are many, but I have tried to take a few judgments because even 1 or 2 judgments are covered in 1 hour time is good enough. Yes, now we are moving to the judgment side. Yes, case laws. I am taking very prominent and renowned judgment. Nowadays, I can see in the tribunal, most of the judgments are passed based on this judgment, which is passed by the Honorable Supreme Court, and very impactful. It has covered lots of things. There are major 5 points which are covered in this judgment. Like members have, many builders or some professionals have raised the issue. Any hearing authority should be having 2 members, one judicial and one administrative or accountant member. Without that, one does not have right to listen any case. Supreme Court has given the clear verdict. This is within the prerogative of RERA or any RERA authority. If they have defined a particular person to hear particular case, they are authorized to do that under particular section, and that has become law of the land, and that has got settled. Earlier, there were lots of cases which were disputed based on this. Now that there is no ambiguity. Second part, which is very important, is Supreme Court has bifurcated a kind of complaints. One complaint which should be passed by adjudicating officer, and what should be passed by the RERA authority or the member of the RERA. These are earlier merged with, and even in Mumbai, there are lots of cases which were combined, like compensation. People have said they have bought the house and a builder did not give within time. They have to pay interest, rent, both things, and they have suffered because of certain something which is not provided by the promoter, and so many things. And based on those things, they have had some complaint with compensation and interest, and composite applications were heard and passed by RERA, were challenged, but some of them not challenged. But in this case, New Tech Supreme Court case judgment, it is now clear. If any matter pertains to section 12, 14, 18, and 19, these will be exclusively, which comes under the domain of adjudicating officer to be heard under section 71 and 72. Under 18, there are compensation part be heard by adjudicating. Rest of the thing will be heard by the RERA authority. And therefore, this is very landmark judgment. Now coming to a very disputed point, which is related to the agreement for sale executed prior to RERA, during the RERA, and in both the situations, there are different 2 situations I am sharing with you. Number 1, promoter given the allotment letter in 2010, registered consider agreement for sale in 2015, and wherein they have promised to give possession in 2016. At the time of RERA registration, project was not complete, and they declared, based on their assumption and fear of RERA's penalty on them if they do not comply later on, whatever they are declaring. Then RERA, they declared a precautionary additional period. Suppose project supposed to be completed in 2 years, they put 5 years time, sometimes 3 years time. So all these things are the practical aspects, and we at times confuse कि बिल्डर को तो रेरा अथॉरिटी ने भी उसने परमिशन दे दिया, दे हैव रजिस्टर्ड द प्रोजेक्ट विद द पर्टिकुलर कंप्लीशन डेट, तो अभी कुछ नहीं हो सकता है, सब मिले हुए हैं, सरकार मिली है, सब मिशनरीज मिले हैं. नो, दैट इज नॉट द केस. First of all, RERA was challenged in Bombay High Court as well as in various other high courts, that this is the unconstitutional law which cannot be passed by the union government, and each and every section of RERA has been heard in Bombay High Court in the case of Nilkamal Realtors, and it was found it's purely constitutional and binding, and that is also settled. Now question comes, it's a retrospective word is not there, retroactive is there. And what happened, those acts registration done before the RERA and which is done later on, High Court says whatever they have promised, a contract cannot be rewrite. Act came later, but the contract has entered before RERA came into, and therefore whatever promoter has agreed to the Allottee in the agreement, whatever time they have given will be delivered possession of the flat or units, they are entitled to get interest under section 18(1)(a) from the promoter of RERA, and therefore after this new tech judgment, that is a settled law. Prior to this, I have many cases, I have seen many cases wherein RERA had been giving the order specifying that RERA come into play from 1st May 17. Therefore, interest will be paid from 1st May 17 onwards till handing over possession. In many cases, there were different explanatory orders also, but now it is a settled law. Even members cannot play with act and provisions. They have to follow the Supreme Court order. Now I am taking on to some say landmark judgment, or I can say important judgment, which is also very critical for us to know. Like in this case, multiple parties had approached tribunal, and in many cases they have given. I have taken one, and similar judgments given. Promoter has not given possession on the revised date of completion. Subject was this. What happened? Agreement for sale was registered in 2013. Promoter agreed to give possession in 2016 February, and promoter registered the project with RERA, wherein they disclosed the possession date as 2019 December. December 18, and thereafter they did not complete. So they revised the project to December 19. At the time of registration, the Allottee have paid from time to time so much amount, and then Allottee have filed complaint before the promoter and paid for possession of the flat along with interest for the delay period, and some further compensation for harassment and mental agony. After hearing of those cases, what is heard is respondent therefore handed over possession of the apartment with the occupancy certificate to the complainant in December 2019. The complainant have approached the authority to at the appropriate stage to demand the interest for delay period. So authority said you should approach, you may approach the authority at the appropriate stage. They did not give the interest to the Allottee. Now Allottee approached the tribunal. What the tribunal said is that case was set aside, and the complainant was allowed interest for the delay period as per the agreement for sale from the 1st March 2016 till the date of actual possession, along with the cost of 25,000. Why I am sharing this? This should give you the more confidence. What is the real picture? What really we are listening in day to day from various places. We should get settled that these are the real final things is going to happen. Even if the RERA gives some judgment, we should not stuck there. We should be fighting on the merit, and later on we will get justice. Now I am taking to Lavasa Corporation case. This is the very landmark judgment. If you see the section 2D and promoter's definition, you will find that any project which is not for sale, it is for the lease and rentals, is not covered. But the Lavasa judgment by Bombay High Court, they have clearly said before that the adjudicating officer in many cases they have declined to give any remedial benefit to the allottees, saying that they are not allottee under section 2D, and promoters are not promoters because these units are given purely on rent, on lease, and lease and rentals are not covered. But after adjudicating officer given this, that matter went to the tribunal, and tribunal went into the detail. They heard the case. They could see that lease agreement was made for 999 years, and lease rental to be paid every year ₹1, and the title of the agreement was agreement to lease. There was no wording agreement for sale. There was no wording for sale consideration, whatever required for executing the sale, and that is nothing but was to take the different route to safeguard from the provisions of RERA. Now, tribunal went into the merit of the case, and they found some important findings. So in view of section 2D, rent is not covered under RERA, as well as promoter is not included as a lessor. In view of the above, no points of giving compensation emerged. This is what the status was of adjudicating officer. Although this order is in maybe hundreds of pages, I have summarized it in 2-3 pages just to bring key points for us to understand. Allottee definition is over here, wherein we can see the last line, case may be given on rent. Allottee in relation to a real estate project means the person to whom a plot, apartment, building, as the case may be, has been allotted, sold, whether as freehold or leasehold or otherwise transferred by the promoter, and included the person who subsequently acquires the said allotment through sale, transfer, otherwise, but does not include a person to whom such plot, apartment, or building, as the case may be, given on rent. The promoter has taken stand of this. This is not given on rent, on lease. Rent includes lease, and therefore this is not covered. Now, promoters, if you see the definition of the promoter, key points, a person who constructs or causes to be constructed an independent building or a building consisting of apartments, or converts an existing building or a part thereof into apartments for the purpose of selling all or some of the apartments to others. Other person includes his assignees, or a person who develops land into a project, whether or not a person also constructs structures on any of the plots for the purpose of selling to other person all or some of the plots in the said project, whether with or without structures thereon. Where you will find it says about selling. It does not say about giving on rent. Therefore, factual is fact is the apartment is given. Apartment in the RERA is defined as a unit, as a flat or office or godown, anything. These are defined as a apartment. Fact is apartment is given on lease for 999 years for rupees 1 lease rent per year in the lease agreement. This is the fact. And then if you see the order of the High Court, after perusing the complaint, agreement for of lease and the provisions of RERA, adjudicating officer has declined. Please to order that the definition of Allottee as given in 2D does not include a person to whom such plot apartment given on rent. And therefore, based on that, he has declined and given the adverse order to the Allottee. And para 10 of the order, if you see, appellate tribunal has relied upon the principle of estoppel laid down in the section 115 of Evidence Act, and thus allowed the appeals and held that the adjudicating officer of RERA has jurisdiction. Earlier, adjudicating officer in the order said he has no jurisdiction because this matter does not fall within the four corners of law of RERA, and he is there for the RERA to comply with. And now tribunal said RERA adjudicating officer has the jurisdiction to entertain such complaints on its merit. The matter were therefore directed to be placed before the adjudicating officer to be decided in accordance with the law. Now, relief granted to the Allottee by the AO as expected, and now complaint filed by the builder in the High Court against the order of the tribunal. And now, Bombay High Court said section 18, AO's right under 18 is maintainable, and AO has the jurisdiction to entertain such complaints. Now, Bombay High Court has given the verdict that the stand taken by the promoter cannot be accepted, and they are covered with various reasons in hundreds of pages of various titles, and the arguments all are very interesting. But result is this kind of thing is also covered under the RERA, and the person buying the flat or the having the agreement to lease is also treated as Allottee. There are few more judgments without touching all those, maybe on the similar lines. Here, if you see the Goregaon Pearl, it is little bit related to more of redevelopment. It is somehow concerned with the RERA also. Therefore, I have taken this. Directly, it is not a RERA case. Bombay High Court arbitration, they have given the verdict. In this case, matter traveled from the Dindosi Court to city, and then appeal, and then arbitration, then Bombay High Court, and then Supreme Court, and came back to a conclusion. If any redevelopment society which was given as per the registered agreement of redevelopment to some of the promoter, he did not fulfill the terms and conditions of the agreement, and then in that case, society has the power to terminate. Number one, in this case, society was given some time to comply with and to give some security or bank guarantee in addition to whatever they had, but they failed. They gave some checks, and that also bounced. And finally, their agreement for redevelopment was cancelled, terminated under High Court. And there were two towers, A and B, and both the towers were constructed. In one tower, more advanced work was done, and then the another one. Then society people requested the High Court so that they can be accommodated in the tower B, which is more advanced, and they can complete that, and they can get house. And High Court, under the judiciary scheme, they formed the scheme that okay, you all people can get accommodation in tower B, and tower A was left for the other people, because RERA registered project, and in both the towers, other than the old members, sellable components were sold to third parties. Therefore, there were registered agreements in both the towers to the third parties, which come in stake. They were afraid कि अभी क्या होगा. They approached High Court. They declined. They said this project was stuck, and now judiciary scheme has come up with this kind, and your rights can be protected with Maharera. You have you can approach your Maharera and get your rights protected, and that was the real picture when people got afraid in this real estate sector after this judgment. See what will happen even if the project is registered. They have the agreement for sale registered, and still those units are transferred by High Court to the society members for protecting their interest. Then what is the fate of the RERA? That matter to that extent is biased if prima facie we can see, but if you see the logic and the hidden resolutions about stalled projects, then at least they have seen that out of two, one they are giving to them, other is still there. Maharera authority, as per whatever thing they can do, they can accommodate them. Might be that can be the intention of the High Court. Now, question is, people, those who are buying flats in RERA registered redevelopment projects, what security and safety they have when the High Court is not protecting their right, when allottees are approaching High Court is declining. No, we cannot protect your interest. It's a judiciary structured project. Another project. This is the what is the finding I shared with you. I can see one more case, Prathamesh society case, which was came to RERA. One of the complainant filed case. This project has been terminated by the society. Builder has failed in fulfilling their responsibilities under the redevelopment agreement, and therefore society has terminated their agreement. And now we want to protect our interest, our rights about the flat. And RERA said, yes, your interest will be protected because you are a bona fide buyer. What they said, their logic was, when the society had given redevelopment right to the promoter, they had become they had accepted them as a agent on behalf of their principal rights. And when the agent is working on behalf of principal, they are working as a principal. Their rights, whatever work has been done, has same impact as good as the society has done. And therefore, based on Prathamesh society's case, Maharera has given verdict in favor of the Allottee, and they said society being the promoter, landowner promoter, they cannot escape from the obligation of the promoter, which they had given blindly. They had not put any condition that subject to this, they will not be obliged with the anything which is promised by the promoter. They allowed the promoter to sell the units. They did not object. They allowed the promoter to collect the money. They did not object. Now builder, whether they have siphoned money for their benefit or something else, how come the society can tell that the person who has purchased the flat in the registered RERA registered project should not be protected based on the Goregaon Pearl case or some other cases, which recently has been adjudged by the various by the High Court. Now it will be helping and giving some relief. And in my personal view, if I see legality of the case, that is the fair case, and it will sustain, because it all depends on case to case and fact to fact basis. In the given case, anyone who is buying the flat is buying, and their rights must be protected. Whether under which act, it all depends. There are different protections available under the Consumer Protection Act or the RERA Act or the Civil Act or some Arbitration Act or some any kind of resolutions which is available to the Allottee, one can take the shelter under that. This is what is a welcoming judgment came from the Maharera so far as the Allottees are concerned, and it might be setback for the society, but I don't think setback it is defined under the RERA provisions. Society is also a promoter, landowner promoter, and the developer coming as a main promoter, and therefore that is a very fair judgment which I say in the Prathamesh case. Now, in this case, Renaissance infrastructure and others, there is industrial unit which was registered with Maharera, and case came about this. In the judgment, I can briefly say industrial unit is not covered. Rest all other things are covered. If you see the meaning of the apartments, that is covering all those things except the industrial unit. Matter went up to High Court, and High Court said, sorry, in the tribunal, and then tribunal said that if industrial unit should have been covered, then it should have been covered in the preamble or in somewhere of the act where they have covered everything except the industrial word, and therefore anything one purchased the industrial unit and promoter did not fulfill whatever is expected under the RERA is not applicable to the complainant. In the landmark judgment of the Samruddhi Cooperative Society versus Mumbai Mahalakshmi Construction, the apex court was of the opinion that the failure of a builder to obtain an OC is a deficiency in service under consumer. This is the another case. Say industrial unit case I already told you, but I am taking you to the one another landmark judgment wherein yes, Madhusudan Reddy versus J. Santhama and others. Here, what happened? The builder who did not have OC and not completed the project fully, yet they have demanded money as a maintenance charge or some other charges, deposits from the Allottee. And Allottee objected. But they said everyone has given, you have to give, otherwise you will not get. Allottee took the possession and complained with Maharera, not Maharera, in the consumer forum. And judgment came, they cannot collect money until they complete the whole project with OC. If there is a deficiency in service under that, then promoter has to compensate. They cannot collect maintenance charges prior to having the project complete with OC. This is the very key and important judgment which everyone should keep in mind. Now I think most of the cases are covered. In the industrial case, normally what happens if someone is going for filing complaint in the Maharera, tribunal demands deposit for the order passed by Maharera under section 43(5). And without filing, depositing that amount, if it is a penalty provisions, then 30% of the total penalty. If other than penalty, then 100% of the amount to be deposited. And there is no leniency. So we all should keep in mind when we are having any kind of case or complaint and order in hand, we should be judiciously file any complaint or appeal in the tribunal for the promoter or for the Allottee. For Allottee, he is not bound to deposit money. Since he is a aggrieved party, he can go and file complaint. But If it is promoter, then they have to comply section 43(5). Without complying 43(5), their case will not be heard. That will be disposed of without hearing. Yes. Over to audience. Any questions now? Vijay ji? Yeah, I can take up a few more matters, but we have 15 minutes time. If you see any member have any query, they can raise the questions.
So as of now, there are no questions, sir.
Okay.
Is Yashish there? Yashish?
Thank you, sir. Thank you, Dilip ji. It was very nice listening this RERA. Yeah. Form 3, Form 5, and then these case studies. Now, without taking much of your time, everybody, I'm sure that everybody has enjoyed. I would request CA Vijay JM, our past PCSE convener, to propose a well-deserved vote of thanks.
Good evening.
Sir, before, if you allow me, before the vote of thanks, I thought there may be a few interactive questions. I want to share something about RERA real estate in a very
Sure.
Sure, sir. Continue,
precise
continue.
manner. Yes. Yes. Yeah. Say now formal session is over, right? I'm
Correct.
just sharing with members my own family, my CA fraternity. We are one. जब भी हम अमेरिका या कोई और कंट्री में होते हैं और कहाँ के हैं तो आप इंडिया से हो तो हम एक हो जाते हैं वहाँ पे। अरे वाह, हमारे देश के। तो हम ये मानते हैं कि हम सभी लोग एक हैं और एक ही फैमिली। जब तक हम मन में नहीं लाते तभी तक हम अलग हैं। और हम एक है तो हमारी कुछ जिम्मेदारी भी बनती है। वी आर लिविंग वेयर इन द सोसाइटीज। हम बॉम्बे की बात करें तो वी आर लिविंग इन सोसाइटीज, एंड सोसाइटीज में आज या तो कल 25-50-100 साल पूरे होते तो बिल्डिंग्स आर डिलेपिडेटेड एंड दे नीड द रीडेवलपमेंट. They need to be redeveloped. New building has to be constructed. Apart of that, the amenities, facilities which were not available earlier, now in this change scenario, we need all those kind of facilities which may be suitable to us. If such are the things, then how that can happen? Because we all are seeing buildings are not completed. If you put in different baskets, suppose if there are 100 cases, so 10 builders might be they are doing the right thing in right time. They are like overrise and kind of builders. But if we look at second level of builders, maybe further 10-20%, they might be completing maybe in given time or little more time. 3 साल का 5 साल में करते लेकिन करके देते. Whether they are doing based on the declared thing or they are compromising might be, but at least घर तो दे देते हैं बना के. लेकिन हम यदि और बाकी का 70% की बात करें तो उसमें बहुत मुश्किल से 10-15% लोग बनाते ही हैं. भले वो 8 साल में, 3 साल का 5, 8, 10 साल में बनाते, बट बनाते तो वो लोग भी थक जाते हैं और बिल्डर भी परेशान रहता है, बट वो देते हैं. लेकिन बाकी का 50 का क्या? No buildings are completed. No chance of getting those buildings completed. What about those things? क्या हम सोच सकते हैं? हम प्रोफेशनल हैं, क्या हमने इस चीज का अपने ऊपर एक थोड़े समय के लिए स्पेंड कर सकते हैं टाइम? क्या हम ये सोच सकते हैं कि उसके लिए हम क्या कर सकते हैं? Being a professional who is running the economy, we are that kind of professional. Our economy is run. यदि हम सीए लोग काम करना, कंप्लायंस का या सपोर्ट करना बंद करें तो क्या लगता है एडमिनिस्ट्रेटिव एंड सीए प्रोफेशन, ये दो पार्ट है जो गवर्नमेंट के विजन को फुलफिल करते हैं। तो हम अपनी ताकत से बहुत दूर है और हम डिपेंड क्या हो जाते हैं, बिल्डिंग का काम है तो कौन करेगा, क्वेश्चन इज बिग क्वेश्चन, डेवलपर करेगा। मैं बोलता हूँ डेवलपर क्या करता है वो जरा देख तो ले हम लोग नजदीक से। इफ वी हैव द इंटरेक्टिव सेशन फॉर मे बी 2 hours एक्सक्लूसिवली फॉर दिस, तो वो बहुत ही इंटरेक्टिव एंड बहुत ही रिजल्ट ओरिएंटेड पॉसिबल हो सकता है। आई एम टेलिंग यू, फर्स्ट आंसर इज बिल्डर करेगा। बिल्डर क्या करता है जरा हम देख ले। तो बिल्डर पैसा लगाता है, बिल्डर मैनेज करता है, बिल्डर बिल्डिंग बनाता है और हमें पोजीशन देता है, ऐसा हमें लगता है। बट मैं आपको बोलता हूँ बिल्डिंग पैसा के बारे में बाद में देखते हैं, पहले बनाता है उस पर देख लेते हैं। सबसे पहले कॉन्ट्रैक्टर बिल्डिंग बनाता है। कॉन्ट्रैक्टर इज अ ग्रुप ऑफ इंजीनियर्स और जो दोज हैविंग एक्सपीरियंस। आपको बिल्डिंग बनवाना है तो एलएनटी को अपॉइंट कर लो ना, दे विल बी डूइंग व्हाटएवर यू आर थिंकिंग, they will be delivering 100% of your expectation. दूसरा, design and all those things are interiors and the architect they are putting and getting it approved. बिल्डर खाली बोलता है 1 BHK और 2 BHK क्या बनाना, क्या साइज का, इतना ही उसका काम। रेस्ट ऑफ द थिंग्स आर्किटेक्ट्स, देन प्लॉट एंड उसका लीगलिटी पार्ट, ऑल आर सोलिसिटर्स एंड एडवोकेट्स, एंड रेस्ट ऑफ द थिंग इफ यू सी MI सिस्टम, अकाउंटिंग, इक्विपमेंट, ऑडिट, सोसाइटी एक्ट का कंप्लायंसेस हो, बैंक से लोन मैनेज करना है, उनसे कोऑर्डिनेट करना है, कोऑर्डिनेशन है, रेरा वर्क है, मोस्ट ऑफ द थिंग्स चार्टर्ड अकाउंटेंट्स। इट मींस तो दो बिल्डिंग के बनने करने के लिए ये जो की पॉइंट्स है ऑल आर बाय थर्ड पार्टीज, नॉट बाय द बिल्डर। देन बिल्डर इज डूइंग व्हाट, बिल्डिंग नहीं बनाता, ये तो क्लियर हो गया, वो पैसा लगाता है और मैनेज करता है। ये 2 पॉइंट रह गए आपके पास। अभी हम आ जाते हैं, हम और आप हर महीने के कुछ पर्टिकुलर डेट को जीएसटी रिटर्न भरना है, टैक्स पे करना है, टीडीएस का पे करना है, उसका फाइल पे करना है, जो कुछ भी है। आई डोंट थिंक कि वी आर लिस्ट बोदर्ड, वी आर वेरी मच बोदर्ड एंड अकाउंटेबल एंड रेस्पॉन्सिबल फॉर आवर क्लाइंट्स। हमारे पास 100-200 क्लाइंट है, फिर भी सबका टाइम पे होता है। और एक बिल्डर का काम है जो उसको टाइमलाइन को मेंटेन नहीं करता है, मींस ही इज नॉट मैनेजिंग व्हाट ही इज डूइंग मिसमैनेजमेंट। हम आप जैसे प्रोफेशनल उसके अंडर में काम करते हैं एंड उसके कहे अनुसार फिर जैसा वो बोलते हैं वैसा करते हैं, मींस ही इज नॉट मैनेजिंग, रादर ही इज मिसमैनेजिंग। अभी हम आते हैं फंड लगाने का, तो बिल्डिंग बन के तैयार होती बॉस, यदि बिल्डिंग में फंड लगाते तो। बिल्डिंग में पैसा नहीं लगाते, आपको मैं बताता हूँ कि वो पैसा लेके जाते, वो आपको दिखेगा अभी 1 मिनट के अंदर। व्हाट दे आर डूइंग, जब भी बिल्डिंग का रिडेवलपमेंट का होता है तो व्हाट वी डू, हम बिल्डर को बुलाते हैं, कोटेशंस देते हैं, उनका एरिया क्या देंगे, ज्यादा कितना कॉर्पस देंगे, वो सब उनको पता है कि 1-2 यदि 100,000 स्क्वायर मीटर का प्लॉट है तो पॉसिबली आपको 1000 के लिए एक टेंटेटिव समझो 1 करोड़ का कॉर्पस देना है, वो रेडी रहेगा। रजिस्ट्रेशन ऑफ द प्लॉट है 50 लाख, वो भी रेडी रहेगा। उसको डिमोलिश करने में तो उनको पता है कि इसमें कुछ रिकवरेबल अमाउंट आते, खर्चा नहीं होता उनका, और कभी हो भी सकता है, तो इतना वो कॉस्टली अफेयर नहीं है डिमोलिशन। देन गेटिंग IOD एंड CC इज ऑल्सो ए मैटर ऑफ मे बी 50 lakhs to 1 crore। तो जैसे उसको प्लिंथ का CC मिला और डिमोलिशन तक का काम हो गया, रजिस्टर्ड एग्रीमेंट हो गया, दे आर विद द सोसाइटी पीपल, उसको खर्चा 2 करोड़ के लगभग हुआ या 2.5 करोड़ का हुआ, दैट्स ऑल। वो पैसा कहाँ से भी लाते हैं, इसमें कोई डाउट नहीं है, कहाँ से लाते हैं वो हम बाद में देख लेते हैं। एंड द मोमेंट दे गेट रेरा रजिस्टर्ड, क्लिंट का उसी है उनके हाथ में, दे हैव राइट टू सेल। अब उनको पैसा ही चाहिए, क्योंकि पैसा एक्चुअल में होता तो क्यों बेचेंगे सस्ते में। 25,000 का माल वो 18,000 में बेच देते हैं, 20,000 में, 15,000 में, 17,000 में। नाउ दे आर सेलिंग की सॉफ्ट सेल। आपको 10,000 समझो माल स्क्वायर फीट का बेचा और बल्क अमाउंट 15 करोड़ उठा लिया, 20 करोड़ उठा लिया, 10 करोड़ उठाया, अभी 2.5 करोड़ खर्चा हुआ था और 10 करोड़ 15 करोड़ उनके पास आ गया, और 2-3 करोड़ खर्च करके प्लेन या फर्स्ट फ्लोर तक आराम से ले जाएंगे। 1 साल 2 साल का रेंट और भी पे करेंगे, उसके बाद रेंट डिले करेंगे, थोड़े दिनों तक पे करेंगे, उसके बाद वो पे करना बंद करेंगे और काम भी कम हो जाएगा। तो व्हाट हैपेंस इन द मीन टाइम, 8-10 crores 20 crores whatever they could divert money from here to there or somewhere else, ऐसा उन्होंने कर लिया। आपके प्रोजेक्ट से उसकी कमाई हो गई, उनको ऐसा लगता है। अभी ये प्रोजेक्ट कैसा कंप्लीट होगा, जिस प्रोजेक्ट में रॉ मटेरियल कॉस्ट बढ़ी हुई है, मटेरियल कॉस्ट बढ़ी है, प्रोफेशनल चार्जेस बढ़े, प्रीमियम्स बढ़ गए, आज के डेट में इतने कम कॉस्ट पे बना पाना मुश्किल है, और वहां पर ये सस्ते में माल बेच रहा है, एंड वी आर हैप्पी कि वी आर बाइंग एट चीपर रेट। जो बाय किए वो भी सफर कर रहे, और जिन लोगों का प्रोजेक्ट वो भी सफर कर रहे। देन व्हाट वी एज ए प्रोफेशनल डूइंग, वी आर लैकिंग वन थिंग। यदि हम ऐसे देखें इसको कि हम उनको उनके ऊपर डिपेंडेंट है जिनके जिनके सारे काम अभी हमारे पास है। हम देख रहे हैं पूरे 4500 तो डिक्लेयर्ड स्टोल प्रोजेक्ट्स हैं, और आने वाले टाइम में ऐड होने वाले। कुछ नहीं हो सकता उनका। क्या कर सकते हो आप? कुछ नहीं। इवन मे बी सम ऑफ यू मे बी हैविंग योर सम ऑफ द सोसाइटी विच आर अंडर रीडेवलपमेंट एंड योर प्रोजेक्ट माइट हैव स्टक। हाई कोर्ट से ऑर्डर आने तक कितने साल निकल जाते हैं टर्मिनेट करने का। टर्मिनेट होने के बाद क्या? अभी मैं बोलता हूँ एज ए अपॉर्चुनिटी फॉर अस। व्हाट इज दैट अपॉर्चुनिटी? लेट मी शेयर। नंबर वन, वी आर drastically missing the entrepreneurial skill, entrepreneurship. Entrepreneurship में क्या रहता है? रिस्क एंड रिवार्ड को ऐड करना है, दैट्स ऑल, और कुछ नहीं। सारा नॉलेज, मैनेजमेंट स्किल, प्रोफेशनल, आप इंडिपेंडेंटली हो सकता नहीं हो, बट जब हम सीए फैमिली बता रहे, वी ऑल आर सीए फ्रेटर्निटी, वी ऑल हैव, तो व्हाई कांट वी यूज दैट एज ए प्लेटफॉर्म? अरे 10-5 लोग ही आ जाओ ना साथ में, सारे इतने 157 लोगों की जरूरत है नहीं उसमें। जिनको इंटरेस्ट बाद में होगा बाद में आओ। एक बार 10 लोग एक लाइक माइंड का सम काइंड ऑफ ऑर्गेनाइजेशन, फैमिली मेंबर को बनाओ, किसको बनाओ, सीए के फॉर्मेट्स को मेंटेन रखते हुए, इंस्टीट्यूट के क्राइटेरिया को ध्यान, वी कैन हैव द एलएलपी और प्राइवेट लिमिटेड और सम काइंड ऑफ ऑर्गेनाइजेशन हैविंग द डिसिप्लिन way of investing, putting money in the specific account to be operated jointly, and people, those who are connected, will get the professional work with the reasonable fees, not negotiated और घटा के उसका रुपये का 4 आना मिलता है रोज होके। नो, you will get reasonable, and payment will also be done on time basis, and everything is part of the cost of the project. It is not that आपने लिया है तो अपने फायदे के लिए कर रहे हैं। मैं बोलता हूँ फायदा भी है, पहले तो हमें वो घर बनना और टाइम पे बनाना है, बिकॉज वी आर प्रोफेशनल पीपल। इफ वी सी 2 साल में बनेगा तो हम 1 साल बढ़ा के 3 साल बोलेंगे, 2 का 5 साल हम नहीं करने वाले, बिकॉज अल्टीमेटली वी हैव टू गो फॉर अनदर प्रोजेक्ट। हम एक काम को कंप्लीट करेंगे तो दूसरा भी करेंगे। इफ वी आर एज ए ग्रुप, हम ग्रुप में फिर अदर प्रोफेशनल्स को भी ऐड कर सकते हैं या हायर कर सकते हैं जिनकी सर्विसेज बिल्डिंग बनने के पर्पज से होती है। देयर कैन बी चैलेंजेस, देयर कैन बी पॉलिटिकल इश्यूज, देयर कैन बी पुलिस इश्यूज, वो सारे भी जब आप काम करते हो रिस्क एंड रिवार्ड में कवर हो जाते हैं। यू हैव टू कीप सम कॉर्पस फॉर दोज एरियाज ऑल्सो, एंड दोज पीपल कैन बी टेकन केयर। आपके जब हम एज ए ग्रुप करते हैं, आप में से कोई बहुत ही साउथ करते हैं, जोर से बोलते हैं, तो उनको बोलते हैं यार ये बहुत ही स्ट्रॉन्ग आदमी है, ये व्यवहार अच्छा नहीं है, इसका बहुत ही लैंग्वेज खराब है। मैं बोलता हूँ वो लैंग्वेज को हम इनकेस कर पाएंगे। देयर लैंग्वेज वैल्यू इज 1 करोड़ से ऊपर की वैल्यू है। हम जो सॉफ्ट बोलने वाले हैं, हम जहाँ सॉफ्ट रह के काम करेंगे, हमारी सॉफ्ट की भी रीजनेबल वैल्यू हमें मिलेगी। देयर दिस इज द पार्ट ऑफ द होल गेम, एंड माय इन्विटेशन टू ऑल ऑफ यू इज प्लीज कम फॉरवर्ड and discuss about this, and the stall projects are waiting to get shoot up, and somebody, the moment some of you, आपका होना मतलब सीए होने से ही नहीं है, आपके फैमिली में, आपके दोस्त में जो ऐसे पैसे वाले लोग बोलते बिजनेस नहीं है हमारे पास, हमें कोई अपॉर्चुनिटी नहीं है, उनको अपॉर्चुनिटी आप देते हैं, उनको कमाई का भी साधन हो रहा है, और उनके इंटेंशन अच्छे हैं आपके साथ में कि बिल्डिंग को टाइम पे कंप्लीट करना है। तो जो स्टॉल प्रोजेक्ट्स है 50% हो गया, अभी काम बंद है। We can have due diligence, we can have some minimum corpus to have due diligence of 5-10 projects। उसमें कोई एक प्रोजेक्ट मन लायक आ गया, हो गया सबका पौवार, बिल्डिंग भी तैयार, सारे अलॉटीज को घर मिलेगा। आपको जो भी रिटर्न चाहिए रीजनेबल 100% मिलेगा, उसमें कोई डाउट नहीं है, बिकॉज ये प्रोजेक्ट ऐसा ही होता है काम। बिल्डर कोई फ्री में काम करने को नहीं आते, दे ऑल्सो सी देयर मैथमेटिक्स, और उनको जब दिखता है कि इसमें 2 पैसा मिलने वाला है, देन दे डू द वर्क। तो आज जो स्टॉल प्रोजेक्ट्स में देयर कैन बी विंडफॉल गेन ऑल्सो, देयर कैन बी आफ्टर कैलकुलेशन में नॉट बी वर्केबल। हम ऐसे प्रोजेक्ट को छोड़ देंगे, लेकिन हम 10 प्रोजेक्ट में 2 भी हमारे हाथ आ गए तो बहुत अच्छी बात है ना, इट इज ए गुड। हम अपने पैसे किसी और में डालते हैं और बाद में बोलते हैं शेयर बाजार में डूब गया, उसमें ऐसा हो गया, ये प्रोजेक्ट में अटका हुआ है, रेरा में कंप्लेंट फाइल करना है। रेरा में कंप्लेंट करना, आ जाओ मेरे पास, आप किसी और के पास चले जाओ, लेकिन जहाँ तक एंटरप्रेन्योरियल स्किल है उसे हमें एक साथ लेके चलने में बुराई क्या है? उसमें आप समाज का भी भला कर रहे हो, अपना भी भला कर रहे हो, और हम आज जो जीएसटी ऑडिट खत्म हो गया, टैक्स ऑडिट का रेंज बढ़ा दिया, हम लोग स्ट्रगल कर रहे हैं कि हमारे पास काम कम हो रहा है, बैंक ऑडिट्स का कम हो गया, कम नहीं हो गया। यू हैव टू सी फ्रॉम डिफरेंट पर्सपेक्टिव व्हाट एल्स वी कैन डू। यदि हम एक सोर्स बनते हैं इस काम को स्टेब्लिश करने में, तो हमारी भी लॉयल्टी इनकम बढ़ेगी उसमें, और द पर्सन हु इज कमिंग विद अस, उनके एक प्रोजेक्ट होते के साथ आजू बाजू के लोग बोलेंगे कि यस, आप लोगों का काम हम लोगों को इंस्पायर किया, हमारा भी काम क्या आप करेंगे, हमारा भी, आप लोग कम भी पैसा लगेगा, एरिया भी थोड़ा कम दे दो चलेगा, आप ही करो हमारा काम। मैं इस स्पेसिफिक उद्देश्य को आपके सामने में रखा, आपने अलाउ किया, थैंक यू सो मच। यदि किन्हीं को लगे तो आई एम रेडी टू टेक द लीडरशिप and to be with you. I am not taking leadership to earn more. No, I want to become with our family members like us and work together and grow together. Ka formula is very much applicable here also, and possibly in the process we can consolidate the CA practice, and that can be also getting the new heights, then having whatever we are doing. Thank you, sir. Thank you, SS bhai.
Yes, thank you, Dilip bhai. Very good idea and very good opportunity you have shown. Even मतलब सुनते सुनते ऐसा लग रहा है कि रीडेवलपमेंट प्रोसेस में ये सब तो कभी सोचा ही नहीं होगा किसी ने. Yes, over to you, Vijay bhai, for very well deserved vote of thanks.
Good evening, members. It's my pleasant task to propose a well-deserved vote of thanks to our today's speaker, C. Dilip Agrawal ji, who has taken the today's topic, that the latest changes, updates in RERA, along with the important circulars, orders, and judgment in a most effective and efficient manner. He has dealt the need for RERA, what are the coverage of the various acts relating to RERA, what are the roles and responsibilities of the promoters, allottees, who can be promoters, then what is a real estate project. He has also detailedly explained form number 3 with respect to the various table A, B, C, D, and also form number 5, the utilization, deposit, and withdrawal. He has taken us through the various important circulars and the recent case laws, which will in fact affect the functioning and working of the RERA, and it will also help the professionals to keep it those judgment in mind while carrying out the attached functions. Sir, we are indeed thankful to you for accepting our invitation to present a paper to this esteemed BCSC study circle. Your presentation was very excellent, and you have spent very lot of valuable time so that BCA can enrich from your knowledge. And lastly, sir, you have answered all the queries which are raised by the members. So on behalf of Borivali Central CP Study Circle, I propose a well-deserved vote of thanks and request the member to carry out with a virtual applause. Thank you, sir.
Thank you, sir. Thank you.
Thank you so much for the opportunity. I think I could justify giving that opportunity.
You have given more than the justification, sir.
Sir, कुछ questions है क्या इधर QA में? Can we see?
एक ही है, 3 है.
अच्छा.
No, wonderful session, sir.
Yes,
sure, मैं ये बोलता हूँ कि हम CA प्रोफेशनल्स को एक दूसरे के साथ में सपोर्ट करना चाहिए. लोगों को लगता है कि कोई भी केस फाइल तो वकील का काम है, वो CA का काम. मैं बोलता हूँ कि CA का जो फाइनेंशियल अंडरस्टैंडिंग है, जो फैक्ट्स को प्लेस करने की एबिलिटी है, वो CA की मतलब मेरिट है. मैं बोलता हूँ करेक्ट. वी डिजर्व टू गेट द बेनिफिट. आज अपने इतने सारे लोग हैं, व्हाई कांट वी स्टार्ट दिस, और व्हाई कांट वी एसोसिएट. दिलीप अग्रवाल जैसे कुछ और भी शायद अपने प्रोफेशन में कर रहे होंगे, क्यों नहीं अपने केसेस जो हम नहीं करते हैं, क्यों वकील के पास हम जाने को छूट दे देते? व्हाई कांट वी डू? It is very positive side from our side. We are attending many cases and getting very good orders from the RERA and tribunal, both sides. लेकिन केसेस ज्यादा कैसे हो सकते हैं? जब हो सकते हैं जब लोगों को मालूम हो कि कोर्ट में CA भी खड़ा हो सकता है. लोगों को लगता है कि ये तो वकील का काम है, आप तो CA हो, आप क्या करोगे? ऐसा बोलते, मुझे भी बोलते, अभी भी बोलते. आप कोर्ट का भी, वकील का काम करते हो? हाँ भाई, वकील का काम करते. वकील के जैसा काम है तो उनको वही समझ में आता है.
Arbitration is also.
Thank you.
Okay, thank you, sir.
Nice.
Sir, thank you.
Our next meeting is on 3rd of September. It's a physical meeting at Batiawadi Hall. Thank you. With this, we will end the session.
Thank you, sir.
Thank you.
ending this
Chalo,
session.
bye, sir. Bye.
Yeah.